Then I filed another motion on the 21st of February, a motion to examine, which is part of the discovery rule. I'm entitled to have all the files that they have in order to find some exculpatory evidence in order to help me prepare my defense. So I filed a motion and I requested all the school records from North Carolina and Florida, 6 different schools. I requested all the psychological evaluation from Florida and North Carolina. I requested all the medical files from North Carolina and South Carolina, because in a case of abuse there's always doctors, psychologists, therapists, psychologists, all kinds of people. I got to have all their files. I'm entitled to it. That's the law. Then I asked the court to give me all the CPT, the DSS, the HRS, all the agencies involved from North Carolina and Florida, that I needed all these files to prepare my defense. A month later, I still had not received anything. So I filed another motion. I requested, once again, that they turn over all the files and records that they had in their possession. And in a pretrial hearing, I requested that my paid psychologist, since I didn't have any psychological report, I hired a psychologist from the University of Tallahassee, Dr. Miller, and I requested that he be given permission to go to the boy's house to interview and to assess and give me a report of his findings so I could use it in court. Now, all I had to do is wait a few more weeks and it was time for trial, but so far I had nothing to go to trial with. I want to give you a very short summary of what an American frame-up looks like. A trial by ambush, orchestrated by State Attorney John Tanner and directed by the Honorable R.O. Watson. But first, today is the day of trial. I have been waiting 6 months now. I have filed all kinds of motion. But first, I want you to know what I've received so far. I have filed a request for all the school records from North Carolina and Florida. The 6 schools, I got nothing. I requested all the medical files from North Carolina and Florida. I got nothing. I requested all the psychological evaluations from North Carolina and Florida. I got nothing. I requested all the files from the 3 different agencies, the CPT, the DSS, and the HRS, all their files and records. And yesterday, I finally got something. I got a 4-page summary, unsigned, transcript, page 140, 41, 42, 43, and 44. It's a summary of nothing. This is the report, the results of 3 agencies working for months on a case of child abuse, and that's what they give me, 4 pages. They also give me one page, a clinical note from David Hackney. He's a psychologist, I believe. Page 107, transcript. And in this 1 page, it talks about my boy not being there, talking to people that we don't see, hearing things we don't hear, and seeing things that don't exist. But that's what it says in here. And I finally got another page, transcript, page 7, a very important page, because I learned that the date that I was receiving love letters from my boys from Florida, mailed by the mother on the 10th of October, on the same week, the HRS got to her and made her sign a 2-page sworn statement describing all kinds of Not child abuse. I'm talking about raping. I'm talking about penetration. I'm talking about everything that you can think of. Unreal. 2 pages. Sworn document for my arrest. She did sign it. She had no choice, otherwise she would have lost the kids. It was so disturbing. It was so far out that even the judge, on the day of the trial, on page 1301 of the transcript, told the jury, members of the jury, he knew that the 2 pages, the document signed by the mother, sworn statement signed by her, were totally false. There was no penetration, there was nothing. Because there's 2 DVDs here. And on the DVDs, never mind penetration, there's no lewd act. And I got him here. And the judge told the jury, members of the jury, Fife is accused of a lewd act on his 2 children. But he did not commit the act of sexual battery. Makes a lot of difference. It carries life. It's the most serious charge in America. You don't get out with this. But he told the jury. But while doing so, he misled the jury with false information. And he told them that my son was a boy, to wit the age of 3 to 4 years of age in 1985, January 1st, 1985, which is a total lie. It's a fabricated evidence. It's a false document, misleading the jury. My son could not have been 3 to 4, January 1st, 1985. He was not even 2 years old. Now the trial started. I had nothing to work with. The worst part of it is, I looked at the jury in the room, and I noticed that none of my witnesses were there. So I asked the judge, Your Honor, can I ask you a question? He said, yes. Page 917 of the transcript. Your Honor, I called a few witnesses last night, and none of them have been subpoenaed. His response was, Mr. Fife, if you had an attorney, your attorney would have subpoenaed your witnesses. You're going to have to live with it. I asked him another question on page 919 transcript. I said, Your Honor, can I ask you a question? Yes. I would like to ask the court to appoint a co-counsel to help me introduce the evidence that I have to help me. His response was, your request for co-counsel is denied. The mother could prove that David Rice was a child molester. I can't. So I called the mother. And when she got on the stand, I asked her, I said, will you tell the judge the day that you went to see the school principal with Tristan, and he told the school principal that your boyfriend was sexually molesting him? On page 787 of the transcript. Her response was, I have never had a meeting with a school principal, and my son never told any teacher such a thing. I knew that she perjured herself. The 4 prosecutors knew she was a perjured witness. The judge knew she was perjuring herself because the principal personally twice wrote to the judge explaining to the judge how the little boy had told her that David Rice was sexually molesting him. He had the letters. So I asked the judge, Your Honor, my